Welcome to the channel. In the last videos, we have discussed about general principles of law as a source of international law. And today's video, we will discuss about equity as a source of international law. So, if you look into that in the earlier sources, for example, custom treaties or general principles of law, there are chances that some cases are like that where you were unable to solve them with the earlier sources. So there is a provision of equity is also there. Equity, basically, when you look into the article 38 in statute of international court of justice, you will find that this particular uh, equity is given in 38(2). That is act bonum. That means by way of equity you can also decide cases. So this particular thing is there, and when you look into that, there are apart from the recourse, which is basically the procedures and institution which the municipal legal system is, if you look into that, that is not available in the sense of international law. That is, domestic legal system is more robust as compared to the international legal system. So we have to look into other sources for the solution. So it is possible that in a number of cases, the references to equity you will find as a set of principles constituting the values of the system. That means you will find this type of things in this. The most famous decision of these lines was that of Judge Hudson in the diversion of water from News case of PCIJ 1937 regarding a dispute between Holland and Belgium. Hudson pointed out that water regarded as principles of equity laws long been treated as part of international law and applied by the court. That means here the court, permanent court of international justice, had tried to convey that even though we have lots of sources are there, but equity has basically have a position in international law as a source of international law from earlier time also. Or, but while going into this particular topic, we have to be very cautious because the interpretation is a very difficult task. Sometimes we interpret extensively or broadly than that definition, particular interpretation can create problem also. So the broadest level, if they will try, at least they try with then broadest level if possible to interpret the equity to basically constitute a creative change in the legal development and producing a dynamic changes in the system rendered inflexible by the strict application of rules. That means where you are trying to try to interpret broadly, and in a way when you're trying to interpret broadly, you will find that you were able to give some substance to the development of international law, and you are able to give something to the system which is generally have a strict application. You will find that in international law that particular system is available. So these are reasons related to this. So there's a case of run of Kutch, which basically regard as an arbitration matter of 1968. So there was an international tribunal was created. The concept of equity has been referred in this case. The tribunal agreed that equity formed part of international law and that accordingly the parties could rely such principles in the presentation of the cases. That means equity has given preference in this particular run of Kutch case of 1968 also, that this particular equity has a position in international law and they have to go into, they can look into this. In the International Court of Justice also, in the North Sea Continental Shelf case, directed a final delimitation between the parties, West Germany, Holland and Denmark, in accordance with the equitable principles, and discussed the relevance of equity in its consideration of the Barcelona traction case also. So you will find that equity is there, and you in many cases you will find this particular the concept of equity. So in Livia Malta case also, that particular in 1985 International Court of Justice has said that the justice of which equity is an emanation is not an abstract justice but a justice according to the rule of law. That means while you're looking into the equity, it's that particular uh, in trying to giving that justice, you should not work only on the basis of abstract justice, but that justice should be as according to rule of law. That means it should be always, the justice should always be the rule of law, which is to say that its application should display consistency and a degree of predictability. That means without consistency and predictability, you can't say this particular justice can be brought to picture. So this is a situation where in the Livia Malta case, they have tried to convey that abstract justice should not be there, justice should with the rule of law should be there. And the use of equitable principles has been marked in 1982 in the Law of Sea Convention also. In Article 59 provides that conflicts between coastal and other state regarding exclusive economic zone are to be resolved on the basis of equity. That means even in the different treaties you will find this particular concept of equity is well established. In Article 74 also, the delimitation of the zone between states with opposite or adjacent coast is to be effected agreement on the basis of international law in order to achieve equitable solution. So in this Article 74 also you will find the position of equity. That means equity is there, and equity is basically supported by different case laws and by the different conventions and treaties also. The Convention on the Law of Non-Navigational Uses of International Watercourse 1997 also lays great emphasis upon the concept of equity. That means they have also tried to give the importance to this. And Article 5, for example, provides that water courses states shall utilize an international water course in equitable and reasonable manner, both in their own territories and participating generally in the use, development, and protection of such water courses. That means if the state is using some water course, and whether it is for non-navigational use also, they have to basically support that, so protect that water resources, and they basically uh, participate in the development or protection of such water resources. These are the examples where you can identify that this equity has very strong position and as a sources of international law. Now another type of source which is available here, that is judicial decisions. So that means if you look into the Article 59 of Statute of International Court of Justice, the decisions of the court have no binding force except as between the parties in respect of the case under consideration. The court has strived to follow its previous judgments and insert a measure of certainty within the process. That means they have, when you look into the judicial decisions, you will find that as per the Article 59 of the Statute of International Court of Justice, this particular concept is given that it will be applicable among the parties also, but it has some importance in the international law also. The decisions are not any only applicable, but there are some importance of this particular judgment also. The doctrine of precedent we all find in common law, but it does not exist in international law. The precedent concept is not there in international law. The judicial decisions not act as a precedent, and it is applicable among the parties only. And judges also, while interpreting laws, create laws in that process of determining issues. They try to create laws also. The Anglo-Norwegian case of physics case of 1951, ICJ, with its statement of the criteria for the recognition of baseline from which to measure the territorial sea, which was later enshrined in the 1958 Geneva Convention on the territorial sea and contiguous zone. That means the statement which was given in this particular way of recognizing the baseline, it finally comes into as a law. 51 the court has given the view, and in 1950 the Geneva Convention was held. The reparation case of 1949 determined legal personality. It is still applicable. You all know that particular case of the that UN peacekeeping forces was killed in the Palestine. So genocide convention of 1951 case dealt with the reservation in treaties, so it is also applicable. So non-bound case of which considered the role of and characteristic of nationality and the range of cases concerning maritime delimitation. So these are cases of examples where the international court has given a strong statement and which is applicable till now. So the concept of precedent is not there, but the cases of strong sense can be applicable. It is not like that every time decision of the court will be accepted in the later discussion and formation. It is not like that every time it will be, but most of the time the cases, if the judgment is good in nature, that it will be applicable in somehow. Lotus case of 1927 of PCIJ, Permanent Court of International Justice, which was criticized and later amended in the Geneva Convention of the law of the sea. This rarely down, most of the time court examine its own relevant case law with the considerable attention and to depart from its decision. That means it is not like that every time it will be there. Sometimes the decisions are also wrong, sometimes decisions are like rule of law, in that case it will basically be not be used again and again. Cameroon versus Nigeria case, the real question is whether in this case there is cause not to follow the reasoning and conclusion of earlier cases. That means we have to look into that what is reasonable, what are the reasons that you should follow this particular previous judicial decision. You have to look into that also. And in judicial decisions, it also includes arbitral awards. Arbitral awards are also part of this, and the rulings of the national courts. There have been many international arbitral tribunals, such as Permanent Court of Arbitration, created by the Hague Conferences of 1899 and 1907, and the various mixed claims tribunals, including Iran US Claims Tribunal. And although they differ from international courts in some way, many of these decisions have been extremely significant in the development of international law. That means even tribunals are there, international bodies are there. So these arbitral awards are there. These are basically help in the development of international law. And this can be seen in existence in number of reports of international arbitral awards published since 1948 by the UN. UN also published the arbitral awards reports, and this basically say that UN also supports the view of the matters which is in arbitration, which are basically arbitral awards are given by the international arbitration bodies. Writers also play very important roles, or we can say highly qualified publicists as a source. That is also scholarly writings are also part of this particular sources of international. Article 38 includes as a subsidiary means for the determination of rules of law the teaching of most qualified publicists of the various nations. That means it is also a part of rules. During the development of classical or modern international law, the reasons for development of international law was due to the work of the philosophers of different schools of law. You will find that the history is basically the development of international law is on the basis of the different writings, different statements of the scholars. Writers such as Grotius, Pupendorf, and Battle and Chancellery has basically given supreme authorities of the 16th centuries and 18th century who determined the scope, form, and content of international. That how the international basically has grown from initial point to till now. It is very much important that the other sources are also other peoples are very much involved. Academic writings plays very important role in the development of the international. That means it is very much important that how the researchers are doing their work. So it is very much important in this case. So you will find that this uh, even these people basically have the writings of scholarly writings plays very important role in this particular development. The General Assembly resolutions also sometimes work as in sources of international. Resolution of General Assembly of United Nations do not possess legal character, such as not binding on the state. They do not create any legal obligation on its member, irrespective of the fact they have been adopted unanimously or overwhelming votes, or even if the context of another matter of common interest for all the state. However, if a resolution is adopted unanimously or by two-third majority of the members, and if the same resolution finds reflection in many other subsequent resolution, it must not be lightly paid. That means if that particular resolution is reflected in different other matters also, so that can you can't say that particular matter is you can't take that matter in light way. It is some important, there is some important. The ICJ in the advisory opinion given in the legality of threat or use of nuclear weapon stated that the court notes that General Assembly resolution, even if they are not binding, may sometimes have normative values. That means whether it is binding or not, it has some value in the eyes of law. They carry a certain circumstances, provide evidence important for stabilizing the existence of rule or the emergence of opinio juris also. So this basically supports the view in generally it is not applicable. Western countries does not want to give credit to General Assemblies as a resolution, but third world countries basically try to use this particular thing as a part. For example, take that General Assembly resolution of UBHR, that is the declaration related to that Universal Declaration of Human Rights is there. Declaration in provision of nuclear weapons of war that is of 1961 is also an example. So these are the certain example which basically say that equity, judicial decisions, teachings of highly qualified purposes, or the General Assembly resolutions also sometimes have some role in the development of international law. So this is an in a view we can say that international law. These are basically sources of international law. In the next video we will study about recognition. Thank you. Subscribe my channel.